It's great to see everyone here. I'm Betsy Knotts. I'm the new director of the state board. And it's just wonderful that there's so many people. And I think more people are supposed to come, and I think they're all going to have to sit in the front row. So don't mind that disturbance. But we had about 100 register, so hopefully we'll fill the room. You know, we at the state board think this is a really important topic, property tax exemption laws. As many of you know, it is one of our core functions at the state board, making these determinations. And you may have heard me say this at the assessor retreat, but I think vital to making good determinations is a healthy relationship between our office and the county assessor's office. Because we need to have the most accurate information from the applications, from the applicants themselves, and the assessor's office when we make these decisions. I just have a few housekeeping items. So I hope everyone got a certificate of attendance. And if you're planning to get 3 hours of continuing legal education, we need to get that back before the seminar ends. So you need to either give it to me or Karen. Hopefully, maybe some of y'all already gave it back to Karen, but we're going to submit those as a group. You can't submit them individually. So if you're getting continuing legal education, please give us that certificate back before you leave. Hopefully everyone got a packet. That will be referenced during the presentations today, so keep that nearby. I also plan to send out a SurveyMonkey survey next week, so look out for an email. I want to get as much feedback and comments as possible and suggestions. We're hoping to take this on the road at some point so we can reach a wider audience. I also want to add some more topics into the repertoire. If you've seen me at the assessor's retreat, you know that I'm interested in tax increment financing and any kind of tax abatement, pilot agreements, and I think there's a lot of interest in that from the public and the legislature. It's a hot topic, so that will probably be a part of this in the future. We may even bring a speaker in from the private sector who actually does those deals, so you can kind of get different perspectives on what's going on in the tax abatement world. And then we have this camera over here, and Kawana's our camera lady. John Dunn from the comptroller's office wasn't able to come today. He's our professional camera guy, so we're handling it ourselves with the state board. We hope to post the audio and the slides on our website by the end of the month. So I know some people's staff members weren't able to come, and hopefully you can access it that way. You won't be able to get credit, but you can still watch it. And I guess at this point, are there any questions about continuing education or any of the administrative stuff I just talked about? All right, so quick poll. I did this at the assessor's retreat. I looked at the roster before I came, so I have an idea of who's in the room, but I think it's good to have the visual hand in the air. So how many of y'all are from actual county assessor's offices or are county assessors? I see Vivian back there. So good majority. All right, and then how many are lawyers involved in property tax matters? Okay, good. And then there's probably a few of us who just came for the food and free CLE, right? Nothing wrong with that. Speaking of the food, Rebecca Alford, sitting right here, she is our newest legal assistant. Why don't you stand up? She's our newest legal assistant, and she handles exemption matters. And she's also a caterer, so I'm very happy to have her on my staff. She does a good job. So basically, I think this seminar, or what I envision for this seminar, is a great opportunity to get to know our 3 exemption designees. And also, hopefully, you'll get a better understanding of the scope of our jurisdiction when it comes to property tax exemption. It is somewhat limited. And I hope you also understand that there's no strict formula when these decisions are made. It's not something you can just plug into a calculator and get a yes or no. It's definitely, depends on the information that's provided, an analysis of that information, and ultimately a judgment call is made. All right, so a little bit about me. Full disclosure about me, and most people probably know this, I'm not a Tennessee native. If you look at my bio, I'm from South Louisiana. My folks, though, are from Chicago, so I don't have a Cajun accent, sorry. But I was very happy when I took one of my IAAO classes recently from the legendary Jewett Farley. I took the assessment administration class, and he is a fellow Louisianian, and he's also an absolutely fantastic teacher if you've ever had him. He's one of those teachers that tells stories and you don't even realize you're learning until like a week later you realize you're doing something he told you to do. Anyway, in his class he said, and I think he's known for valuing a Bengal tiger, is that right? I think he bragged about that in class once, which I thought was very entertaining. One of his sayings is, if somebody else has a good idea, just steal it. And so I'm going to steal his bus analogy because it's just too good to pass up, and I think it helps kind of frame what we're going to be talking about today. So if Jewett Farley were here, he would ask the whole room to pretend like after the seminar is over, we all go out to lunch. So I think Husk is not far from here and is very fancy Southern food. So we'll all go out to lunch. We'll all order chicken wings and shrimp and grits and cake or whatever, decadent dessert. And then right before the check comes, a charter bus pulls out front of the restaurant. And this side of the room, all of a sudden pulls bus passes out of their pockets and says, we're leaving. And so they all go out and get on that bus. And the rest of us are sitting there with the check. And what are we going to do? We're going to pay the check. But I only ate one lunch. I'm now paying for two. And we're going to wonder, why did they get a bus pass and I didn't? And in essence, what we're talking about today is bus passes. Why are certain properties exempt from taxation and others are not? Why did the legislature, and many legislatures, probably every legislature across this entire country, decide that it was appropriate to shift that tax burden onto the non-exempt properties? And I think we can all agree that we don't want to just hand out bus passes. And we want to put some thought into it, and we want to keep good records of them too. So one little last thing about me, and I promise I'm not this self-centered or anything. I am all about the big picture. And so I want to give you a big picture nugget to chew on while you're learning today. The exemption statutes in Tennessee, as many of y'all know, are construed liberally in favor of the taxpayer. So they are construed in favor of religious, charitable, scientific, and educational institutions. And over the summer, we did some comparative research, and we looked at kind of what other states do. And I think Texas was one that construes their statute strictly, but they write their statute more broadly. And as my mother-in-law would say, well, and in Tennessee, you're going to see very specific provisions. You'll see it on the slide. So they get nicknames like the Habitat for Humanity provision or the Goodwill provision, and those are construed liberally in favor of the applicant. And so my mother-in-law always says it's 6 of one and half a dozen of the other, and that may apply here. It may not matter whether you're specific and liberally construed or broad and strictly construed. You may end up at the same results, but we're kind of wondering, are those results an inconsistent tax policy, and is that the best we can do? So I don't have an answer to this question, but it's something that we're thinking about and talking about, and we'd love anyone else's input as well. And so that's enough for me. I'm going to introduce our main presenters. First, we're going to hear from Sabrina Williams. She is our West Tennessee designee, and she's been with the state board for over 15 years. She's got a Bachelor's of Science in Mathematics, and she received her law degree from Vanderbilt, and she's a member of both the Tennessee Bar Association and the American Bar Association. Robin Pope will follow her. He is our newest hire, and he serves as the East Tennessee designee. He's been with us for less than a year, and I will say that he has hit the ground running. We are really enjoying having him on staff. He also has a Bachelor of Science degree from MTSU and a law degree from Belmont. And then last but not least is Miss Emily Bennett. She's our Middle Tennessee designee, and like Sabrina, she has also over 15 years of experience with the state board. And she also has a Bachelor's of Science. They're all BS's in psychology. That's right. And she has a law degree from the University of Tennessee. So they're a great team of attorneys, and I love having them on staff. So let's go ahead and get started. Here you go. No BS.
Hello, everyone. I'm really glad you chose us instead of the CMA activities. The state board has put on exemption seminars for a number of years. This one is somewhat different. In this one, the three of us will attempt to address different aspects of exemptions. Robin will discuss the application process, and Emily will discuss why it's not always so easy to make a decision about exemptions. And I will try to give you some historical perspective on exemptions and take you through a tour of the statutes. Now, what we would like to do is to reserve the questions until the end of the seminar. So during the presentation, if you think of a question that you have, just jot it down, because we're going to have a question and answer period at the end. Now, my biggest challenge is the technology. So, okay, so why do we even have exemptions? I need to take you back to the year 1870. So 1870, we're 5 years out from the Civil War, and at that point, there had been two state constitutions. I think one was in 1796, and the next one was in 1835. But in 1870, there was a constitutional convention, and during that convention, this constitution was drafted. So they met in January of 1870, and in March of 1870, it was ratified. The state constitutional principle of this particular constitution, and this forms the basis of the state constitution that we have today. It says in Article 2, Section 28, that all property, real, personal, or mixed, shall be subject to taxation. Okay, so that's pretty clear. If all property is subject to taxation, then why do we have exemptions? The reason we have exemptions is because Article 2 also says that the state legislature would be able to make exceptions for a number of things. Two of those things are government-owned property, which was later codified TCA 67-5-203. And the second of many exceptions, religious, charitable, scientific, literary, or educational institutions, which was eventually codified into 67-5-212. Who decides what property may be exempt? Well, the assessor gets to decide the government property, and these are just examples: housing authorities and certain cemetery properties. The state board decides religious, charitable, scientific, and nonprofit educational property. So the focus of this seminar will be the exemptions that are handled by our office. As you notice that in the Constitution, it mentioned literary, but when it was codified, it just said religious, charitable, scientific, or nonprofit educational. So the religious, of course, would be churches. Charitable would be things like United Way, volunteer fire departments. Scientific, we actually do not get a lot of, but there is one in Memphis, the Medical, Educational, and Research Institute. And then the nonprofit educational properties would be schools, colleges, and things like that. Remember that exemptions that are handled by the state board are not automatic. An application is required. Also, I need you to remember this. Nonprofit does not mean that the organization does not make a profit. Nonprofit actually relates to the way the entity is organized. Even though a nonprofit can be profitable, the thing is that unlike a for-profit entity, doing so is not the primary goal of the nonprofit. Okay, so you have the main exemption statute. It's 67-5-212. And the primary principle of 212 is that property that is owned by a religious, charitable, scientific, or nonprofit educational institution is eligible for exemption consideration. Again, not automatic. This principle includes things like parsonages and things that are not listed, like community gardens and nonprofit hospitals. The other thing is that the property, those 4 categories define the type entities that are exempt, but they also need to be used for an eligible exempt use. So, why am I showing you a tree? The reason I'm showing you a tree is because when I first started working for the state board and I came across all of the different statutes and all of the different things that were actually embedded in 212, it made me think of a tree. So the way I look at it is that 212 is the tree trunk. And then the roots are the things that are specifically mentioned in 212. I look at the branches as the statutes that were enacted that all relate back to 212. So when I'm discussing the exemptions during this presentation, I will be referring back to the exemption tree, the roots, the branches, and then later on some things that are not necessarily on the tree. So let's start with the roots of 212. Again, these are the specific situations that are addressed in the statute. One thing would be a lease. So 212 allows a lease to take place between 2 exempt entities. And I'm not going to get too much into that because Robin is actually going to discuss that. I've also, during my presentation, I'm giving you where you can find it in the code book. So the lease would be discussed in 212A1. Parsonages. The statute allows a church to have 1 exempt parsonage. It's not to say that the church cannot have several parsonages. It's just that only 1 can be exempt. And there's a limit to the land to 3 acres. So it can be no more than 3 acres. The statute does not define how a parsonage can or has to look. So a parsonage can look like this, just a regular home. Or it can be fabulous. It can look like the Kardashians live there. And when you open the door, it can look like this. So, I don't know what the Lord feels about that. The exemption statute does not care. Okay, another rule, 212D. That refers to nonprofit membership organizations chartered by Congress. So an example of that would be Boy Scouts of America or Girl Scouts of America. 212N, thrift stores. And my hope in my part of the presentation is that at some point you say to yourself, wow, I didn't know that was eligible for an exemption, and you learn something new. So I don't know if you knew that thrift stores were eligible for exemption, but they are. There are certain criteria. One is it has to be a training venue for those needing occupational rehab, or it must be a store primarily operated by volunteers. And the inventory must be donated, it must be sold for very little, and if someone shows up in need, there needs to be a policy where that person or that family can get help. An example, of course, would be Goodwill. 212H, fraternal entities. And when I say fraternal here, I'm not talking about college fraternities. Although college fraternities are eligible for exemption, they normally get a 50% exemption. Fraternal entities here are organizations like VFW Post, American Legion organizations. And if you can see in that picture, it does say VFW, and it's a bar. So a lot of VFW posts have bars. But in these fraternal entities, an exemption for them, the revenue producing areas like the bars are not exempt. So the areas that are used for the meetings and charitable events, those things would be considered eligible for exemption. 212E, labor organizations. An example would be the Electrical Workers Union. Again, if they have any revenue producing areas, those would not be exempt. Again, charitable or educational uses only. Now, I listed all of these on one slide because we don't see them very often, but I wanted you to know that they are eligible for exemption. So 212, the roots of 212, you have nonprofit artificial breeding associations. We don't see that very often at all. County fair associations. We have seen this, and there was a question about the Lincoln County Fair Association. It's been a big controversy, but again, we don't see these very often. Caretaker housing and community park. So that is if a park is open to the public and they have a house where a person resides and is supposed to discourage crime. So that's eligible for an exemption. Caretaker residence owned by a member organization. Remember I just said that a member organization was something like the Boy Scouts of America or the Girl Scouts of America. And they may have a home for the same reason where they have someone there to discourage vandalism. Public radio, public television. When those statutes were enacted, they pretty much applied to Nashville Public Radio, Nashville Public Television. It's not limited to that, but I think that was the motivation behind those. 212O, land limit. I'm not going to get into that much because Robin is also going to discuss that. But in 212, the land limit refers to land that does not lie underneath an exempt structure or improvement. Okay, so that was the last of the roots, the things that are actually specifically addressed in 212. So now let's talk about the branches, the statutes that were enacted separately and all relate back to 212. The first one is TCA 67-5-207, permanent low-income housing for elderly and disabled persons. Okay, notice the words permanent, low-income, elderly, and disabled persons. So that particular statute has a lot of criteria. If there are more than 12 units, the property owner must make an agreement to make payments in lieu of taxes. The project must have been financed by one of the enumerated federal or state or loan programs, state grant or loan programs. The exemption may continue, and this is fairly recent, the exemption may continue after the loan is paid off as long as the project is restricted to elderly or disabled persons as defined by the program. Now, in terms of the enumerated programs, the state grant or loan program, it used to be that the two main programs were house and home. Home still exists, but house does not. But a recent AJ decision approved the substitution or the replacement program for a house. So it's a housing trust fund. So it is eligible for an exemption. So what happens if it's not permanent housing? suppose it's transitional housing, suppose it's temporary housing, then that can be considered under the main exemption statute, which is 212. Another branch of 212, TCA 67-5-213. It relates to certain educational institutions. It says that dormitories are eligible for exemption. And when it says dormitories, it's not just what we typically think of as dorms. It also includes single-family homes that are occupied by students. It says that the residence of the head of the college or university is eligible for exemption. The residence of the faculty member or staff member, and there are restrictions, would be eligible for exemption. And also the college university bookstore would be eligible for exemption. In terms of the residence of the faculty or the staff member, one restriction is that if that staff member or faculty member no longer works for the college or the school, that person cannot have an ownership interest in that home. So, again, a number of restrictions in terms of the occupancy by a faculty or staff member. TCA 67-5-214, cemeteries and monuments. Remember I said that the legislature had the authority to make some exceptions and that there were some exemptions that were decided by the assessor and some exemptions that are decided by the board. Well, if there is no charge for burial, the assessor can make the decision and no application is required. An example of that would be like a church cemetery or a family cemetery. But if there is a charge, then they have to file an application with the state board. For-profit cemeteries and monuments are eligible for property tax exemption. And the interesting thing about this to me is that this is one of the rare cases where a for-profit entity is eligible for an exemption. So when you think about cemeteries and monuments, you typically think of something that looks like that. But it can also look like this. And I recently had an application for this. It's Serenity Columbarium in Memphis. And so you have these places for urns. So it can look like this. And if you get a chance, I really recommend that you go online and look them up. Again, it's the Serenity Columbarium. It's an amazing, amazing place. I had no idea. I did not give them a 100% exemption though, because the statute relates to the places of burial. It doesn't relate to the funeral home where the sale takes place and things like that. So they only got a partial exemption. Another branch, 67-5-221, low-income housing owned by a charitable entity. And this is something that Betsy was referring to because we call it the habitat law, but it can apply to any type of organization that operates in a similar fashion. Property held for construction of one or more single-family houses to be conveyed to a low-income household for residential use. And as you know, Habitat acquires property and they build a home on the property. Generally, the future homeowner takes part in the construction of the home, and then at some point the keys are turned over. Under the Habitat law, or this particular statute, it is exempt during the period of ownership until conveyance to a low-income household. And there's a mathematical formula, and I majored in math, so I like that part, mathematical formula to determine the maximum period of exemption. Now what's odd about this is that with most exemption statutes, there's only one date that we have to determine, and that date is the exemption effective date. But when it comes to properties like these, you not only have to determine the exemption effective date, you also have to determine the maximum period of exemption. And the way the formula works is that the maximum period of exemption for the first property is 18 months. But for each property after that, there's an additional 6 months that's allowed for a period of exemption. And generally, when Habitat sends in applications for exemption, they say they bought a lot that had X number of acres. Habitat's plan is to subdivide that lot and build several single-family homes. I've had situations where I've got an application for 127 homes. So the first property is given an 18-month maximum period of exemption, but the other 126 lots, you multiply that times 6, and you get into 70+ years for the maximum period of exemption. The thing is, Habitat very seldom takes that long to build a home, but it's been an interesting thing. It's been an issue of whether or not we need to change that, but it didn't happen. So I just need you to know that there's a mathematical formula if you run across something that's similar to Habitat. 67-5-223, community and performing arts. The example I'm using here is the Country Music Hall of Fame. It must be owned by a nonprofit community and performing arts organization. It's used for public museums, art galleries, performing arts auditoriums, and theaters. There are strict guidelines regarding the organizational structure. The reason I use the Hall of Fame is because, again, that application came in and the Davidson County Assessor's Office and I went out there and we went floor by floor by floor. We looked at all of the displays and the exhibits. They were given a partial exemption because they have restaurants in there, and also they leased the place out for different functions. And it was more, it was a pretty substantial lease that they were, for weddings and fundraisers or whatever. So they were given a partial exemption. The strict guidelines regarding the organizational structure would include a minimum number of board members. It has to be organized in a certain way. An employee cannot make very much money, if any, off of functions. So the criteria is laid out in the statute, but that's an example. Another branch of 212, 67-5-225, Family Wellness Center. The example is the YMCA. When this was enacted, there was a lawsuit by for-profit gyms because they were upset that the YMCA, in their minds, was doing the same thing that they're doing, but they were getting the bus pass, like Betsy mentioned. The lawsuit failed. The statute stands, and it says that any entity that is exempt under this statute has to have as its historic sole purpose the promotion of physical, mental, and spiritual health. And that's not going to apply to a lot of, wellness centers. The other interesting thing about this statute is that there's a heavy focus on the nature of the entity. Normally with religious, charitable, scientific, or nonprofit educational institutions, there's a focus on the nature of the entity, but there's also a focus on the nature of the use. Here is heavily focused on the nature of the entity. Under the statute, the entity has to provide at least 5 of 8 enumerated programs For example, summer programs for children and teens, daycare programs, aquatic programs, and there must be some income-based fee structure. The reason I said it was heavily focused on the nature of the entity is because shortly after its initial enactment, there was an application filed on behalf of the Y, and it was for a location that did one of the 8 enumerated programs. Say, for instance, it had the aquatic program, and it was denied. So it was looked at again, and it was determined as long as the entity offers 5 of the 8 enumerated programs, then the property would be eligible for exemption. So that means that because the Y offers 5 of the 8 enumerated programs, that the location where it's just the aquatic program would be eligible, the location where maybe a daycare would be eligible. So it's not just based on the use at that particular location.
Excuse me, question. Okay.
Oh.
I have a question.
We're gonna hold the questions to the end. But hold on to that question because we want to answer it, okay? Okay. I'm listing these branches much like I did the roots of 212 because we very seldom see them. We have 67-5-210. It's an economic or charitable development organization. An example would be Memphis Incubator Systems. As a matter of fact, I think that was the organization that initiated the enactment of that statute. Then you have 67-5-218, historic properties. You have 67-5-222, again, historic properties. You have TCA 67-5-224, which is another economic development statute. And then you have 67-5-226, which is a museum statute. Now, here you see 2 economic statutes. So what are the differences? In 224, it's a very, very small statute, and it basically says that the entity provides small business counseling. It can even provide some office space for some charitable entities or something like that. 210 is a very recent statute, and 210 is much more in depth. And it says things like the property is used to commercialize technologies into scalable businesses. It says it provides affordable office or lab space and shared meeting rooms. So it encompasses some of what you see in 224, but it goes into a lot more depth. As I said though, I think that Memphis Incubator Systems was the driving force behind that statute, because the statute also says that 210 only applies to a nonprofit entity that has been in continual operation for not less than 10 years from May 18th, 2015. The thing about exemptions is that you're able to almost trace every statute to one situation. And sometimes, like this is pretty specific. 10 years in business from a specific date. The historic properties, 218 and 222. 218, I'm gonna be honest with you, 218 is just confusing even to us. We don't even know what they were trying to do. It's very, we've never used it, it's very convoluted. And if you read it, if you want to go to sleep, just pull out 67-5-218. Or you want to be confused, pull out 218. We've used 222 more because it's more straightforward. It talks about the property being on the National Register of Historic Places. So it's more straightforward. I don't know, I'll have to do some research to see what entity they were targeting when they did 218, I'm not sure. The museum exemption in 226, remember a few minutes ago I was talking about the museum exemption statute that was used for the Country Music Hall of Fame. Well, when I was looking at the Country Music Hall of Fame, I actually also considered 226. It says it displays local, regional, historic crafts and different things. So I considered 226, and I reached the same conclusion that the museum should be given a partial exemption. But 226, I think, is more, Emily will probably have an example of that, but it's more for smaller museums, like regional type crafts. Okay, so far we've talked about statutes in terms of branches, but I've also included as a branch of 212 some state board rules, a couple of state board rules, because every now and then we have to interpret or we have to clarify a particular issue. So the first rule is Rule 0600-08-.02, and it deals with the exemption of land. And remember I told you that Robin's going to talk about the land limit in 212.0 that deals with property or land that's not underlying the structure. In this case, there must be actual use of the land and a rebuttable presumption of use is established if the property underlies an exempt structure or paving, if the total land being claimed for exemption is not more than 5 acres, and if there is excess land, it's necessary for zoning reasons. You may have a situation where, because of the use of the property owner needs to form a buffer. So they may need a certain amount of acreage to form a buffer. There's a presumption of that. Again, it's rebuttable. Now, land that's held for future use is not exempt, and we get this quite a bit because churches may have plans for a future family life center, or they may have plans for something else, and the land next to their property becomes available for sale. So they seize the opportunity and purchase the property, but if they're not using it, it's not going to be eligible for exemption. So we've had that quite a bit. It's like, well, we're planning to use it, we're a church, we own it, but land held for future use is not eligible for an exemption. Land held solely for conservation or preservation reasons must show active use on the land. So you have a property and it's being preserved in its natural state, which is a good thing. But unless there is some active research on that land, it's not going to be eligible for exemption. So if you have UT Knoxville coming on the property and researching the flora and the fauna on the property, then it becomes eligible for exemption. But just because it's being held in its natural state, that's not an exempt use. The next rule of the state board is 0600-08-.03. We also refer to this as the clinic rule. Why did we need this rule? I'll discuss a little bit later, but nonprofit hospitals have a presumption of being charitable. So at some point, hospitals like St. Thomas started buying doctor's offices, and they started saying, oh, we have the presumption of being charitable because we're St. Thomas. So this clinic that we just bought should also enjoy that presumption. But we determined that that was not the case. So then we needed to have some criteria for clinics. A clinic here is defined as a facility providing primary medical care other than the hospital or other licensed healthcare facility. The property must be located in a medically underserved area, or the facility must serve an underserved population. The service is provided to the patient without consideration about the ability to pay, and the physicians and the employees receive reasonable compensation per industry standards. I think that I want to point out, how do you determine if it's medically underserved or an underserved population? There's a website you can go to and you can call up a particular area and it will tell you if it's a medically underserved area. Okay. The legislature, the state board, and the courts. I mentioned that the 1870 state constitution gave the legislature the authority to determine what situations are eligible for exemption and the criteria for exemption. The legislature designated the state board as having the responsibility to determine what situations meet the criteria. Courts sometimes have to step in to clarify and interpret the exemption law. As I mentioned, the state board also adopts rules for that same reason. And when those actions are done by the state board and the court, that can lead to non-listed exemptions, what I call non-listed exemptions. These are exemptions that are not on that exemption tree that I mentioned. So some examples of the non-listed exemptions. From court cases, you have the nonprofit hospitals. I think it was the 1928 Baptist Hospital case that established that presumption I mentioned earlier about nonprofit hospitals being considered charitable. I'm not sure. It's interesting because when you tell most people that, they're surprised that nonprofit hospitals are given that presumption because they point out stories where people have shown up with no insurance and the treatment was not necessarily charitable. So, but they do have that presumption of being charitable. Another example of an exemption that resulted from a court case has to do with denominational publishing and printing. So secular publishing and printing would not be considered eligible for an exemption. I think the Christian Home for the Aged was a case that established the nursing homes as being eligible for an exemption. So all of these things, if they had just been, in fact, that was the reason they were denied exemption. So it's not something that when you see religious, charitable, scientific, or nonprofit educational, you would normally think of a nonprofit hospital or a nursing home. So the courts have interpreted that and clarified that. Now there have been times when the court has said, no, this is not exempt. An example would be missionary housing. We get a lot of applications from churches where they are applying for missionary housing, but it's been determined that the missionary housing is more benefit to the missionary than the people who benefit from the missionary services. So the missionary goes out into the field, does the missionary work, and then they come back for rest and live in the missionary housing. And that's been determined not to be an eligible exempt use. Another thing that has been determined not to be an eligible exempt use are chambers of commerce. So these are non-listed exemptions through state board action. And again, non-listed, I'm saying things that are not on that tree that I showed you earlier. And often, our action comes in because of trends. An example would be community gardens. A few years ago, we started getting all of these exemption applications, and they were all for community gardens. One entity may submit 11 applications for a community garden. So it's like, why is this happening all of a sudden? Well, it turned out that the Memphis Land Bank was conveying property that it had gotten through tax problems and things like that to nonprofit entities. The statute 67-5-2509 gave them the authority to do it. It said that a municipality can convey real property suitable for community gardens. And the point of it was to take this land that had been swept up in tax problems and to prevent neighborhood blight. So instead of having land being overgrown or trying to sell it to a private person, they conveyed it to a nonprofit. It was being used for a community garden. It adds beauty to the community. Produce can be distributed to the community members, and so it serves a purpose, and the Memphis Land Bank saw it as a win-win. The reason we addressed it is because, okay, if this conveyance can take place, what would we need to see to convince us that it's eligible for exemption? So we determined there must be ownership by an eligible entity. There must be active use and not just planned use. There must be some demonstration of controlled use or access, and through evidence, photos, maps, some demonstration of the policy in terms of how the produce is distributed to the people in the community, and also the budget to reflect that an expense has been generated that directly relates to the creation of a community garden. The final thing that I would like you to know or remember is that the Constitution gave the legislature the authority to determine what is eligible for exemption, what the criteria would be, but exemptions are a privilege and not a right, and that applications must be filed and a determination made. And that ends my portion. I will turn it over now to Robin, and he's going to speak with you a little bit before the break. Thank you for your time.
Hi, thanks for coming in today. My name is Robin Poe. I'm talking about applying for your exemption. So as Maria's talked about a lot of the types of exemption that exist in Tennessee, I'm going to actually go through how you go about actually getting that bus ticket, as Betsy talked about. You will see me, and I'll be the one who actually gives you that ticket. So I am the East Tennessee exemption designee, and so we separate applications based upon grant division. So I do East Tennessee, Sabrina does West Tennessee, and Emily does Middle Tennessee. And so one of the things I would like to do is see a show of hands. So if you're from East Tennessee, if you just raise your hand. Okay, there's a few of you. Thanks for coming in today. I really appreciate it. East Tennessee is not only my grand division, but close to my heart. I have some family out there as well. Thank you. Okay. So today, after today, you're going to know how to get your exemption, you're going to know how to apply for your exemption. So when someone looks at you and they go, "You got an exemption?" You can go, "What? It's hard?" Shouldn't be a big deal. Exemptions aren't the hardest thing in the world to get. You just have to first qualify. You need to be an organization that deserves to get that exemption. And then you also still need to put in the paper. You just still need to get in your application in. Unfortunately, it's not just going to be an automatic process. Hence, my first often asked question is, my organization is a 501c3, we're already exempt. Why am I applying? I don't understand. And the main point is that the 501c3 designation is going to exempt you from your revenue taxes and some federal taxes. This is state property taxes. This is a whole different ballgame. So you have to apply. We do look at your 501c3 status, and it is helpful because it does show that you kind of like already made those steps, that you're most likely are charitable. But you do have to apply. And the other question is often, we're already granted exemption on one piece of property, like do we have to apply? Like I don't understand. The answer is yes. The exemptions are granted both to the entity and specifically tied to the property. So you have to apply on every parcel and every piece of real property. And so I hope if there's anything you take away today, is that you need to make an application on every single parcel of real property you own. I had a law professor once who always said, the three worst organizations in America are churches, schools, and law firms. And churches were kind of number one for a reason. And as you'll see, there are a lot of special circumstances when it comes to religious entities. And partly it's because they're smaller in nature and the fact that organization members may come and go throughout the years kind of ends up being, there's always a little piecemeal, a little extra help sometimes. So the application process is pretty simple. There's a paper application, and all of you should have received an example filled out application as part of your materials today, which we will go over in a small light group activity. You can also make your application online. It's the same information. You can find our application available on our comptroller's website, and you can also find out the status of your pending application there as well, and I will show you how to do that. You need to make sure that when you apply, you have a separate form for every parcel. Again, because I'm going to feed it into you, you just need a separate form for every parcel. Oftentimes churches will forget to apply on a parcel, and then it'll end up causing many complications once it goes up for sale. So you need to upload all your required documents. What required documents you might need? Some things might seem self-obvious, some things might not. So you need things like your warranty deed. The number one thing we need to see is that you own the property. It's a statutory requirement that the organization applying for an exemption actually own the property. You can have a leasing situation, and I'll discuss that in a minute. However, we do need to say who owns it, as well as other things like your corporate charter and bylaws. For incorporated organizations, this kind of just shows your nonprofit nature. Your financial documents, your tax returns if you filed them. This is a good way for us to see how you spend your funds, like do you actually spend them in a charitable way, as well as photographs of the property and in a personal property report if you're applying on personal property only. You need to also then continue with your application, pay the appropriate fee, and provide copies to the county assessor. This is a statutory requirement that's required for taxpayers and organizations applying for exemption. They're supposed to submit all the identical information they just sent to us to the county level. And be aware though that your documents that you're submitting to us can become public record. SBOE, we don't usually like to throw things away. We have documents going all the way back from 1910 to 1907. We are required to keep your exemption applications and the documents you submitted us, or key documents, for at least 10 years. So if you make a selfie with your duck face with your church in the background, you're like, that might be in the books for a really long time. So once you finish your application and you paid your fee, you have your warranty deed, your application will be forwarded to one of the SBOE attorneys. We will kind of review that for some preliminary stuff. So as I said, we're going to verify your ownership. That's the first thing we're going to look at. If you do not own the property, you can't show you own the property, you're going to be booted out the door faster than anything else because we just, we can't do anything. We're going to confirm the property location, make sure that you got the right parcel ID, that you're identifying the right property, and confirm preliminary aspects of the nature of the organization and preliminary qualifying fees. So in your application, you identify what you're using it for. When I'm talking about the nature of the organization, it's kind of things like Sabrina talked about earlier, when you talk about YMCA and things like that. We're going to look at your nonprofit charter. And so, we don't necessarily disregard or kind of do. So your corporate form is important, and we're not going to just completely ignore the fact that you are an incorporated nonprofit, but we are going to look at your documents. Organizations, might seem charitable. If I had the, charitable foundation of Robin Pope, you might kind of look at a monkey and be like, what? And so you start looking at it, and so we look for things in your charter to know that you are in fact a nonprofit organization, you're in fact charitable, you're in fact a church. Things like you have to have requirements that are often the same requirements for your 501c3 filing, which are that you can't have board members be compensated unless you report it, you can't have specific individuals benefit, you can't have, upon the dissolution of your organization, you can't have all the profits and proceeds go to a specific, for-profit entity or an individual. It has to be truly charitable, including in your corporate form. After we review all your documentation, we kind of look through everything, we see that, all right, everything looks good, that they've checked all the marks, they've provided their, photographs and everything else like that, they own the property. We're going to do one of three things. We can approve the application right there on the spot, see that they've otherwise satisfied all the requirements for an exemption. We can deny the property, saying that they don't own the property or they're not, their corporate form is not charitable in fact, or we can request additional information. So the SBOE attorney is allowed to ask for anything we may require, whether the property qualifies for exemption. So this can be a lot of different things. Often organizations can get a little flustered. And, we try to make these requests simple. We enumerate everything we're trying to ask for, and always welcome out questions with regards to providing additional information. And so, we may ask the applicant to clarify things about how they're using the property, or we may try to ask for clarification about, why does your income statement say that you're paying John $200,000 a year? Like, who is John? And then we can also request an assessor's review. So as you might have come here today, you realize that the state board is located here in Nashville, and as are all the three Tennessee exemption designees. But we operate for charities and churches and nonprofits across the entire state, every county from Kingsport all the way down to Shelby County and Memphis. And so we often will ask our county assessor partners to go out and look at the property and make sure that, the applicant is using it the way they say they are, that they're not trying, they gave us the best picture but not the full picture. And so we do rely on those partners to kind of help determine whether these applications, deserve a bus pass. So, first is the use of the property. And so we're going to look at the structures of the property. We're going to review each use of the building and the underlying land. We can prorate the exemption based on the exempt use, and the assessor's input is often most helpful in the situation. So things like this is oftentimes what will happen is that, if you have a church, a large church, but part of your church is a bookstore, you won't get an exemption in the bookstore. One of the main requirements is that you cannot be taking on the same sort of commercial activity that a for-profit business would be engaging in. And the idea is because, again, you want to encourage those uses that benefit the community, and you don't want to disadvantage for-profit businesses who have to pay a property tax when you may not. And so again, part of the policy reason behind this is that we want to help compensate churches and nonprofits and churches for the public benefit that they're doing in their communities by exempting them from property taxes. Now, without structures, it gets a little bit trickier. Unoccupied and unused land does not qualify for exemption. So if you have an empty field, you're not just going to automatically get it. However, vacant, and unused, vacant does not mean unused. You can have a large empty field that is used for your, outdoor, after-school, nonprofit, recreational, sort of youth program. And so you can have these uses where you have large, unimproved property that can still qualify for exemption, but we are going to be, looking for evidence of uses. And so we will, kind of ask our county assessors to go out and look at the property. Does the property look mowed? If they're saying kids are playing it every day and the grass is 4 feet tall, like what are they doing? Are they are they hunting for Pokemon in the tall grass? We're not only then concerned about the safety of these children, as best as we can be, we're pretty incredulous if you're using that property. So let's assume everything looks good, we believe you, your application looks good, the county assessor has looked at the property, your photographs match and everything else like that. We're like, all right, we're set for an approval. We're gonna give you that bus pass, you're gonna get out the door, and you're gonna, get out of property taxes for the, in compensation for the benefit you provided to the community. An approval is going to do a bunch of different things. It's going to become as a letter to your to the applicant contact, as well as we send copies to a bunch of different people involved in the process. It's going to identify what is exempt. So like I said earlier, you can get a partial exemption. And so if you only get a partial exemption, it'll identify what property is exempt, what property is not exempt. It's also going to identify when in time the exemption begins. We're going to send copies to the applicant, the county assessor, and the county trustee, the three main parties involved with your property taxes. It's also going to include a copy of your original application and soon be paperless. We are in the process of switching to a paperless system, and it will, it should be the greatest and best thing ever. But we do currently still send out paper copies of everything as well as email copies. So again, does an approval exempt all property owned by the applicant? And as I've tried to stress multiple times, no. It only exempts what is applied for, and you need to apply on every piece of real property owned by your organization if you want to be exempt on that property. It can be partial, it's going to be based on proportionate use. So as I said, if you have a bookstore that's engaging in for-profit activity on your large church, and we're going to look at the square footage. If you have, just for math purposes, if you have 100, if you have 100 square foot, piece of property, only 50 square feet, this is a very small piece of property, 50 square feet is used for a for-profit, business, you're only going to get 50% exemption. And so we do look to make sure that that partial exemption is based on something. We're going to make sure it's either based on use, or if the building takes up all of the property, we're going to base upon the use of the building. And so this might end up being a percentage of your overall value on your property tax assessment. It might end up being based upon the specific, the structure. The building is exempt, but your large 5-acre field is not. Approval is not going to do a couple different things. It doesn't transfer. So if you're exempted on a piece of property and you sell that piece of property, that exemption expires. Like it doesn't travel with you. It doesn't transfer to the new owner. It doesn't transfer to you if you buy property from an exempt entity. It doesn't expire. There's no need for you to reapply every year. There's no need, it's not temporary. But it doesn't mean it cannot be revoked. And yes, it is a double negative, but you can lose your exemption. And so Emily will cover kind of how that process works later. Your exemption is also going to have an effective date. There's a lot of dates, so kind of bear with me. So in 2017, if you applied before May 20th, your exemption date can be January 1, the date title was transferred, or the date use began, whichever is later. And so, we can't just, we're bound by these requirements, and so we can't just wave a magic wand and make your exempt property, exempt whatever we want it to be. We do have to, follow these effective date rules. There are a lot of them. There are almost as many exceptions as there are rules. And so what this kind of means for this May 20th deadline is that you can only get an exemption for the year in which you apply. So again, 2017, if you applied before May 20th, you can get an exemption for 2017. Unfortunately, if you bought the property 3 years ago, 2015, 2014, we can't help you with those previous years. You have to apply within, as soon as you get ownership. If you don't, you run the risk of having back taxes and taxes that you will need to pay. We can only help you for the time in which you actually apply. Applications received after this May 20th deadline are either going to be the application filing date, and we do take your postmark date, so it's the date you put it in the mail, or the date you hit submit online. And we use the date use began if the application is filed within 30 days. So you do get a grace period. If you buy the property and you apply within 30 days, there is a grace period for you to apply for your exemption. It'll be the day you put that in the mail, and we can save that date. there is a special exception. So again, everything's an exception. There's a 3-year throwback rule for religious entities. So it's a transfer from one exempt religious entity to another religious entity. It can be, it's cross-denominational, it's cross-religion. It's really just one religious entity to a religious entity. If I use church to church, it's the same thing, but it doesn't have to be in a church. It could be a Buddhist temple to a church. It could be a church to a, I don't know. It could really be any religious entity. Or replacement for religious entities' prior exempt property. So the two most common situations are when a church moves, they bought a new piece of property because their congregation has expanded to a point where they needed a larger facility, and they moved to this new facility, they can get an exemption, and they can also get they can wait 3 years to apply pretty much. Now we don't recommend that, it's very bad. You can always, something can always go wrong. You could think you were previously exempt and you weren't, so you should always apply as soon as you can. But again, like I said, the 3 worst run organizations in America, churches, schools, and law firms. So the churches kind of, do have members who come in and out. Someone might have meant to apply, and then they stop attending. They might have, moved. Churches are very sort of analogous form, and so they do kind of get this protection that they can get one tax bill in the mail, look at it, like, well, we're exempt, just throw it away. And then get a second tax bill in the mail, and look at it, and be like, I don't understand why I got this one either. I'm going to give it, to my pastor, and pastor forgets about it. And then usually what happens is they get more threatening notices about how their property is going to go up for sale, and that's when they start realizing, oh, maybe I should have applied. And so this kind of protects churches. It's a decision that the legislature made. They wanted to protect these sort of smaller congregations and kind of give them some help for not losing their property.
Could you finish that example? I mean, I know it's not a question, but you're saying they throw it in the mail, get it again, throw it in the mail, get another bill, and then their property's up for.
Yes, so they finally apply.
Okay.
They finally apply, and so let's say they bought the property 2 years ago. They finally realize, they finally get it together, they submit their application. So we still follow these kind of effective date rules. We're gonna look at when they mail it and everything else like that. But we can actually go farther back than the current tax year. So like I said before, most organizations, we can only go back to January 1. That's the earliest we can go back. If you bought the property the year before, there's nothing we can help you with. The exception is for church-to-church transfers or church replacement properties, in which case we can throw that exemption date back, like we're throwing it in the pond, we're going back up to 3 years before. But it's up to 3 years before. If they for some reason have 4 years that they didn't apply property tax, we can't help them with that previous time. We can only throw back that effective date. And so it has to be effective, so they do have to be using, they do have to own the property. We can't throw it back to the previous owner. And the idea being is that if Walmart sold a property, you don't want to give Walmart a tax break by giving them an exemption for part of the year. But there is just that special protection level for churches. It is tricky, and again, I do not recommend churches rely on this provision. There can often be several hiccups. They could have bought it from a church who thought they were exempt and they were not. They might not have records of it. It's a dangerous territory. It's always best to apply as soon as you can. But again, there's just, there's a special protection. Why does it matter? Because this is when you pay taxes. So if you don't apply May 20th, you apply, July 1, you may have taxes for that first half of the year. The effective date really was when your property is no longer subject to taxation. And so if you've owned your property for longer, you might still have to pay taxes on it. And so while you're waiting for your exemption, you've gotten that delinquent tax notice, you're like, okay, I've applied, what do you have to do? You can pay under protest. You can say, I think I'm going to get an exemption. I'm not going to have to pay taxes, but I'm going to go ahead and pay it because I'd rather be safe than sorry. The taxpayer can do a refund if the application is later approved, or they can await the initial determination. This is a very personal decision that organizations have to make of how they're going to use the funds in their budget. Are they going to pay this tax bill that they think they're going to get refunded on, or are they going to await initial determination? Now, if they're approved, the payment will depend on the effective date. So churches, your organizations can make this sort of personal decision that they're going to use their funds in this way, and they're going to say, no, we're going to take that money that we're supposed to pay in taxes, and we're going to feed the homeless. We just think it's the right thing to do. It's it's what we budgeted for. It's how we're going to operate. And so when they're approved, everything turns out okay. They can use those funds effectively. They've helped people who are in need. Unfortunately, if their effective date doesn't go back far enough, there might still be a period where they owe taxes. And there's not, a lot we can do as an office. We can determine their effective date, but if they still owe taxes, they still owe taxes. And so again, sometimes it's better to be safe than sorry, to pay under protest, but some organizations just don't have the funds for that. So it's always a personal decision. It's always something you need to be aware of if you're going to advise someone about whether they need to go ahead and pay taxes or they can wait. It's really going to be a personal decision, because if they get denied, they're going to owe all those taxes with interest. Unfortunately, this can result in organizations going under. They might have used all their funds on other purposes and they have no money left to pay taxes. And so, hopefully that shouldn't apply. If they were feeding the homeless, we would like to think that they got that exemption. But it's always a tricky choice if people decide to pay a protest or await their determination. So we're going to do an application example. So as you've received your materials today, you have an application example. This is often kind of what comes into our office. And so during the break, I'm going to ask you if you want to review this on your own, but if you've had a chance already, we're going to kind of do a couple of things. So here you got your application, and with your application, you got supporting documents. You got a valid executed warranty deed identifying the parcel applied for as signed and dated, so they received title on November 26, 2016. You got a copy of their tax return, and here's the lovely image that they supplied. It's a rather large church building with a parking lot out front and a couple of cars in their property. Looks like this is a nice fall picture. And so, by show of hands, I was going to ask everyone, just by looking at what you've seen, would you approve? Kind of raise your hand. If you will, let's first do deny, because I want to see who's going to deny. If you would deny this church, raise your hand. Yeah, I don't think so. If you think this church qualifies and you're like, all right, you're just going to go ahead and rubber stamp it, they've submitted everything, go ahead and raise your hand. No? And who wants more information? Okay. And so during this break, I'd like to ask if you want to talk to your neighbor about what you would do, and be prepared for our group activity when we return. But we're going to have a short, about 15-minute break, and get some coffee or water or sandwiches, as well as. So I'd like to just provide a couple additional facts. So you got this application, and so at the state board, we get our applications in. The first thing we do is we Google them. To be honest. Google Earth has massively changed kind of how this process works. We're actually able to more or less in real time pull up that image. And as well as the county GIS mapping data often has more accurate information, and we'll always have some of the best aerial views of the property. But this is partly why we always ask for a non-aerial picture when you submit your application, because I can use Google Maps and Google Earth as easily as you can. What we cannot do is we can't see the inside of your building. We can't see what the current field looks like. A lot of churches will buy a new piece of property and build on it, but Google Maps and the GIS data still has a vacant field. So we really need you to send out pictures in that are real, actual pictures, and not something that we can just get in our office. It doesn't help your application. So when we find out, we look at the property card. We find out the property is actually 95 acres. And here is a aerial view from the GIS data. So that church building, we gotta remember, this was the picture we had. It was a big building. We find out it's even in a bigger piece of property. And on Google Maps, you can actually zoom in, and you can see there's a cornfield up out in there. There's a corn maze, actually. You can even see where the tracks of the maze go. And it's right next to a commercial development. I think it's a grocery store, like a Walmart or something right next door. And so that parking lot is kind of, the entire thing is a parking lot, both for that church and then, right next door is the, kind of Walmart sort of parking lot. And then here's another picture of the church. Again, seeing more of the side of it, you can see that there's, this additional back side of the building. It seems like a much more larger facility. And you can see, some vans in the right corner, kind of like, what are they doing? You're trying to like look at this property. So, now that we kind of have seen more about this property, we kind of see more, what would you like to do now? We'll start with always denial, like this is taxpayer friendly, so I want to see how people are a little harder on their taxpayers. Any denials out there? Just right here. No? Okay, so I wouldn't deny it either, right? Not outright. How about approve it? Who just, wants to rubber stamp it, thinks, 95 acres sounds, fine and dandy. No? Okay. So I guess we're all going to have some additional questions or kind of at least ask for our assessor help. And so one of the things you also need to determine is that if you're going to approve the property, when does the exemption begin? And so part of our group activity is you're going to talk to your neighbor for a few minutes about kind of what information do you want to know? Like what, if you're going to give this person a bus pass, like why? Why do you think they deserve it? And how much land do you think they deserve? Kind of what information are you going to ask about? And then once you talk with your neighbor and kind of come up with your plan, we're going to quadruple up with pair and square share. When we get back, we're going to kind of talk more about what happened to this property in real life. So I'm going to give you all about 3 or 4 minutes. Talk to your neighbor. So I hope you had some common questions. I don't know if anyone wants to kind of like self-volunteer. I'm not going to make you, but if anyone wants to raise their hand of what they would ask, I would gladly accept that. No one? Okay. I see no hands. So I'm wondering if y'all notice, there's no corporate charter. It's something that's kind of easy to gloss over. They included a copy of their tax return and their warranty deed, but we don't have a corporate charter, which is one of the required documents that we do ask for. We do find out that it's 95 acres and kind of additional property. You might have noticed some peculiar things in their application. They both marked religious as their uses as well as educational, which given the size of the building kind of makes me inquire, like, what is this building being used for? They say uses are, their church sanctuary and offices and other activities, which is somewhat vague. We do kind of ask that every use is kind of qualified, but again, we're still one of the worst organizations in America, churches, schools, and law firms. And it is taxpayer friendly. So we do kind of give the taxpayer a lot of leeway. We do construe the statute liberally in their favor. And so, we as the government civil servant will try to reach out and kind of, ask them more of what they meant, even if they do not identify so in their application. So kind of this is based, obviously it's fake information, but it is based upon a real property tax exemption that was applied for. You probably want to ask things like, what are you using all your acreage? And they're going to say, yes, yes we are. We're a church. We're the most honest of churches. So of course we're using all 95 acres. And so sometimes our assessors will kind of help us out a great deal here. They'll kind of send the assessment officer out and kind of look and they'll say, oh, based upon like my review, it really seems like they're actually using more like 15 acres. They have like a soccer field out there. They have a field they're using for their yearly fall, ramble, activities, all that stuff. And then you find it is a school. So you might be asking more about the school, kind of like, is there a program? Do you have to pay to attend the school? Is this a private school? Kind of like, what's the organization? They said no one leases the property, but sometimes, they don't lease it because their for-profit educational school is also them. So sometimes you do want to sort of identify and sort of investigate. And so, we're not here to kind of be hard on churches, but we do kind of help investigate to make sure that we're going to give them an exemption, that they actually do qualify, and the uses of the property should in fact be exempt. So in reality, The actual church this is based on was ended up being approved for approximately 15 acres of the entire building and the 15 acres of the surrounding land. The other portion of the property was deemed non-exempt, and they still do have to pay taxes on it. The county assessor kind of helped out to kind of determine the acreage as well, and so we do send them our responses, and hopefully they did respond to those. If you don't respond to our responses or requests for information, you might be denied your application. We do need people to be responsive, and so when you identify a contact person on your application, that's the only person we contact. We look to see that they actually respond, and so it's important that you pick someone who's trustworthy and responsible, who's going to be there and respond to requests for information. Now, at the State Board of Equalization, we do have a maximum of 6-month processing time, which might seem like a lot, but remember, there are literally 3 people who do it for the entire state. Oftentimes, a lot of people apply in October, November, the fall months. That's when they're getting their property tax assessments. Reassessment years, where people get their property assessed for its value, are often popular years to apply. So there is a maximum of 6 months. I don't think we have one that has currently taken 6 months at all. But again, the more complicated the exemption, one such as this case where you find out it's actually a school and there's a lot of acreage and they're really contentious with you about saying they use it all, might take significantly longer than your small 1-acre church building. So exemptions can take a while to start to determine, because again, we do want to make sure they actually do deserve the exemption and that we're only exempting property that's used. And also, if you notice, the effective date. They gained ownership in November 26, 2016, but their application, I don't think they applied until 2017. And so we have to go back and look at those effective date statutes. And then they also identify that it's a church-to-church transfer, it was a replacement property. And so we need to go make sure that that's actually true. Like, is there a record of the property being exempt? Is there a record of their previously property being exempt? And so we do kind of pull from our records and sometimes the county assessor to make sure that that effective date can actually go back to November. And so in this case, their effective date would have gone back to November 26, 2016, I believe. And we would have determined what amount they would have been exempt on. But again, it was a partial exemption, so their taxes they would have owed on the non-exempt property from the date they began ownership. I'm trying to make sure everything else we covered. So that's, so exemptions, Emily will kind of talk to you about some of the weirder exemptions that we get in Tennessee, but as you can see, sometimes, seemingly simple churches end up being a lot more complicated. I don't know if anyone had any, I'm willing to take a couple of questions about the example if anyone had. No? Christine?
Okay, so I have a question. If they are saying that their current structure, church sanctuary and adjoining buildings as of July 1, 2015, because of the 3-year throwback, them being in church, can you go back if they've been using it?
Yeah, I'm actually really glad you caught that. I did put that in there in front of the example because, churches, again, they might have been renting this church, and we're about to talk about leases, and then eventually bought it to replace their other property. And so that is important to identify because sometimes these churches will, gain sort of, use and actually start occupying the property before they actually gain title to the property. And so let me just kind of talk about leases, and that'll probably help kind of explain how that works a little bit. So leases, an exempt institution can lease a portion of their property to another exempt entity and keep their exemption or get an exemption. However, the following criteria must be met. The property owner, the lessor in this case, must be an exemptable entity. And that they must independently sort of qualify for an exemption. And the non-owning leasing entity, the lessee, must be also equally qualifiable for an exemption. The non-owning entity must use the property for exempt purposes, so you can't rent it to a church within the church open Starbucks. They both have to be using it as for exempt purposes. The owning institution can receive no more rent than a reasonably allocated share of the cost of use, excluding the cost of capital improvements, debt service, depreciation, and interest as determined by the State Board of Equalization. So we do kind of determine that. So we will look at that amount of rent. We will kind of look at the cost of that. And, the applicants are more than helpful when they supply additional information relating to that cost of use. If they can show an amortization schedule, if they can show the price of utilities and show that they just pay for the cost of utilities. These are all sorts of things that we look in for leases. If an entity is not eligible for an exemption and it leases to an eligible exempt entity, the property does not qualify for an exemption. Unfortunately, I gave this answer to church not too long ago, who had some very interesting language they used to respond to that. And unfortunately, we get this question a lot, but this is the answer we have. It has to do with the statute. The statute requires ownership, the property owned by, and then specifically covers leases. And it says they have to have all these requirements in it. And so unfortunately, a lot of churches will contract around the property taxes. This is kind of moving back to Christy's question about property taxes, in that if they're renting a facility, but they contract to pay the property taxes on the building, oftentimes, their location, their information will go on their property tax assessment data. They'll otherwise be responsible for paying that. However, if they don't, it'll end up being the owner who has to make the decision whether to pay those taxes or forfeit their ownership. And so partly, if you think about it, there's two main reasons of why kind of leases operate this way. A, is it's just what the statute says. It refers to properties owned by exempt institutions as being exempt. And the second is you think more about the policy. Who do we want to give that bus ticket to? Yes, we want to give it to charitable organizations that are doing good work, that are benefiting the community. And East Tennessee's got a lot of interesting exemptions out there, and a lot of nonprofits doing excellent work, helping their communities in very interesting ways. And sometimes that can include leasing, sublease agreements with other exempt entities, and that can all be fine. However, you don't want to give an exemption to Walmart who's leasing it to, a church. You don't want to give these for-profit individuals, or individuals or for-profit companies this tax break, essentially. You want to give them a bus ticket the same time you're giving it to the church. And so for leases in this way, you don't want to allow that sort of advantage going to someone who doesn't actually benefit the community, or at least not in that sort of direct, tangible way. The important thing to remember about this is, again, you have to apply on every piece of real property, but you can also apply on your personal property. So if a church is renting a location, so a food kitchen might be a good example. If they're renting the location from some sort of for-profit entity, they're renting it from, I keep using Walmart, but if they're renting a large facility from Walmart warehouse, but they're operating a charitable organization that provides food and clothing to the homeless, they might have that industrial kitchen inside that building, and so they might own that equipment. They might own that industrial-sized, fryer and everything else, the laundry services, and they can get an exemption on that personal property. But they still have to apply for it. And so that is often kind of what comes up when you talk about leasing, is that personal property can also be exempt, but they do have to apply on it. If you otherwise own the real property, the personal property and location is presumed to be used for the same purposes and will be exempted, usually automatically. You can also get an exemption while you're under construction. So like our example, if for say they started constructing on the property before they actually had title, they wouldn't necessarily be responsible for those taxes, but if they did own it and they started building on it, you can get an exemption from and after, but not before the commencement of construction. You can only to the extent of the value of the improvements constructed, and the improvements must be used and occupied for exempt purposes upon completion for a period of 10 years, and construction needs to be completed within 5. This is a very kind of weird, bulky construction statute, and often involves a lot of kind of moving pieces with regards to the value of the constructed house or constructed church that you're building on the property. It's kind of a compromise. It both kind of, you're not using the property because you're not in the property, you're building it. So you don't really want to say the entire property is exempt, but at the same time, you want to recognize that you can't use the property because you're building on it. And so it's kind of a catch-22. So in this sort of case, you get an exemption as to the value on your property assessment for the value of the buildings, the improvements, but you might still have to pay tax on the underlying land. Again, these sort of factual determinations can be very intense, very specific. Evidence of when construction begins and when construction is supposed to end, pictures, documentation, sort of construction notes, builders, sort of contractual agreements are helpful. And it is going to be a partial exemption for that period of construction. Right now, our current offices typically holds those applications for about a year. We do follow up to make sure construction is completed. But if you do get a partial exemption under a construction sort of permit, then you will need to update our offices once your uses change and actually occupy the property. Otherwise, you might still be paying taxes on the underlying land when you could get completely exempt. As Sabrina mentioned earlier, there is a land limit. This such a provision, I believe, was enacted as a direct sort of result of a large exemption that was granted in Tennessee. I believe it had to do with the elephant sanctuary. So you have a limit of 100 acres of land per county, and that is necessary to support the exempt structures or site improvements associated with exempt structures. This is empty, unimproved land, and so just a limit. They don't want people getting exempt for an entire county if they still have bought all the property. You have to actually have buildings on it and you need to be using it for an exempt purpose, but you can't have more than 100 acres per county essentially. Now, again, this is for unimproved land, so it's just land that is not occupied by any sort of structures or anything else like that. So most often this comes up in terms of nature preserves, wolf preserves, hawk preserves. We got a lot of wildlife in Tennessee that needs preserving apparently. And so they would be a nonprofit charitable organization that has these large stretches of vacant land. They can get an exemption, but unfortunately there is a limit. So some final tips and things to remember when applying for an exemption. The organization, do they need to submit a separate application for personal property? And the answer is no. Personal property is presumed to be in the same use as the real property. The only exception being is that if you don't own the real property, then you need to apply separately. With exemptions, you can prorate assessment of personal property, and the proration will be based on the effective date of the exemption. So again, if you're being taxed on that personal property, then it will be, we follow the same effective date rules that we would for any other application. Finding out the status of your application, you can do simply online through our comptroller's website. It's kind of an interesting place, but so in the same place you would go to sort of find out how to apply for your exemption and find that online application form. You can go to the comptroller's website, and under boards, it'll be State Board of Equalization, and under online resources, we have status of exemption sort of option that you can go and you can search by name or county or applicant name, or every exemption record has an exemption record number. And so you can look up the status of your exemption there, and it will tell you, we try to update these applications every time some progress is made. So it'll say new application is filed, it'll tell you when the application's been forwarded to the attorney, it'll tell you when the attorney has sent a request for information, if the attorney has asked for an assessor to go out and look at that property, and when we've received those responses, as well as the final determination for that organization, whether they were approved, denied, or was partial. And with that, I hope you have a firm understanding of how to apply for an exemption in Tennessee, what to look for, and like everything else about your exemption needs, really. Again, worst run organizations, churches, schools, and law firms, and you have to apply on every piece of real property. And with that, I'm going to hand it over to Emily Bennett.
So we're on the downhill side now, and the good news is I'm going to show you a bunch of pictures before we get to the not so exciting topic of revocations. So I think by now we've probably hit home that churches don't really look like necessarily that picture there on the left anymore. We have a lot of mega churches now here in Tennessee, and with those we have to look at, as I think we've mentioned a few times, we may have a coffee shop, we may have a bookstore, we even may have a gym in there. We have some administrative decisions that say, bookstores, for example, are not necessarily disqualified from exemption, but we've got to look at Is it open only during hours when there are church members there? Are they advertising to the public? Is it operated by volunteers? Same thing kind of with coffee shop. Are they just putting out coffee for members and maybe you can give a donation? So also there you may be looking at a lot of acreage. Maybe that church building isn't the only structure on that property. Maybe we have a parsonage. Maybe we have another residential piece of improvement on that property, and it could be missionary housing, or they could be using it for some kind of an outreach ministry. So we get these applications, and sometimes there's just a lot to dig into, and there's a lot of questions we have to ask on our end to figure out what's going on. This is an example of kind of like your religious retreats, religious camps. So the picture on the left is actually from an application I had not too long ago, and it was somebody's, I think, mansion in East Tennessee, and they donated it, and it's owned by an entity now that claims to be using it for religious retreats. And you know, that's different than what you're looking at over there on the right. That's a campground, and maybe it's a little bit easier to figure out. Over there on the right, you might have a chapel. You've got some cabins there. They're probably having summer camps for kids and things like that. So, you know, these are all questions we have to ask and try to figure out, are there really religious activities happening here? Animal refuges and sanctuaries. How many acres does an elephant need? Well, Miss Williams had to actually try to figure that out, and I think she went out and rode around on a golf cart and got real close and intimate with the elephants. The picture on the right, I actually had a tiger sanctuary, and they had a few mobile homes on that property, and there was staff living in those mobile homes. I had to work in conjunction with, I believe it was TWRA, to try to determine, are those trailers necessary? Are they required to have staff present on that property? And what I learned was they did have to have staff. So while we probably typically don't approve staff housing for exemption, they demonstrated there that it was required for them to operate that property. This is an example. A lot of times we're trying to figure out what statute applies. So, you know, the museum there on the left, the museum statute that Sabrina talked about earlier may actually allow for us to approve that property for exemption, but also we may look at it under the general exemption statute because it may also be considered educational. Then you've got Country Music Hall of Fame there on the right, which she already stated that she looked at under the Community and Performing Arts statute, and there was a lot of analysis that went into making that decision in terms of how much of the time is this being leased and how much of the square footage is occupied by restaurants and other things that don't qualify for exemption. This is the Lane Motor Museum that's here in Nashville, and we have an opinion on that where the administrative law judge found that this was a charitable entity. They allowed people, I think, to come in free of charge sometimes, and the charge was pretty low. So, I mean, there's a situation where they're calling it a museum, but we're looking at it, it's qualifying for exemption under the general exemption statute. This is the Tennessee Aquarium, and I think Sabrina actually went and visited that property as well. And you can see it's a large facility. There's a lot going on in there, and I believe that's an entity that was approved for exemption under 212. But these are just the kind of things, you know, we're not looking at sometimes just small churches or things that are obvious. We're really having to go out sometimes and tour these properties and go look and see what's there, or do our best to draft requests that we can obtain the information from the taxpayer that we need to make the determination. On the left here, we have a hospital, which we've already heard that hospitals have a presumption of charity. But with hospitals too, sometimes you have cafeterias, gift shops. Typically, gift shops are not going to qualify for exemption, but we have a court case that says cafeterias and gift shops in hospitals, they're an integral part of operation of that hospital, and so those are going to be approved for exemption. Property on the right there is a very large senior living community in East Tennessee. You've got a nursing home, you've got an assisted living facility, you have apartment complexes that are just for older persons, but they're independent living, so it's just like any other apartment that somebody could go out and rent. So I had to look at that and try to figure out what building was what, how much of that, nursing homes and assisted living facilities are licensed healthcare facilities. So they enjoy that presumption like hospitals. So those portions qualified for exemption, but the independent living apartment units could not be approved. So there was a lot of analysis that went into that application. Next thing I'm going to talk about really is how can the assessor's office help us? And we really do rely on information we get from the assessor's office. And I guess the first thing we would ask is that when you do get an application, just take a look at it and make sure that the information on the application kind of matches what's on your records. If it doesn't, let us know, email us, call us, just let us know. And you can also do that. There's 2 or 3 things listed on here that can be accomplished through an assessor's review. An assessor's review is typically, we're going to request that typically as part of our application review process. But if you don't get a formal request from us, you are welcome to submit that information, and we would love to have it. So in addition to the information you put on the form, which is going to be, verification of the name of the applicant, the value of the property and things like that, if you go out and you take photographs, or you have a sketch or a map, or maybe you see something, you guys are our eyes out there. We're sitting in an office in Nashville. I can't see it. So anything you can tell about use, or you may have some knowledge about the organization that we don't have, please share that. And acreage is huge for me, because I'm just not really great at looking at a map and being able to say, it looks like they're using an acre. So I really do rely on information from the assessor's office there, and I'm also going to give the applicant the opportunity to provide that information as well. Sometimes you might want to go out and conduct an on-site visit. We do recommend just be mindful of situations that might require scheduling an appointment. So we do get applications sometimes from domestic violence shelters. We've had an application from a sex trafficking shelter. And so there are situations where you don't want to just show up on a property unannounced. So just be mindful of that. This is on the right is just an example of what our assessor review form looks like. You don't have to fill that out if you don't want to. We really just want the information, and so if you would rather just shoot us an email and let us know, or call us on the phone, that's okay. Really just looking about what are your observations about the property. So does it look like it's actually being used? If they've said on the application it's being used for storage, can you tell? Are there really things being stored there? Is anybody there on the property? If it's a church building, a parking lot, just look at all that and confirm, or you can say, I went out there and looked, and that's not really what it looks like. I don't think that's what's happening there. And you can obtain this information through the site visit, as I mentioned before, but you could also knock on the door and interview somebody, or talk to the neighbors, or talk to somebody you see there around the property and ask them what's going on. And I really do, like I said before, I love to get photographs that the assessor has taken of the property, because usually it's going to be more than what I got with the application, and it may show me things that I can't see on that piece of paper that I got. So this is just some examples of, I get an application, this property is next to a church building, and they told me this is a parking lot. So what would be helpful to me here is, hey, I went out there and I looked at that, and it doesn't look like that this property is being maintained at all, and there's trash strewn about everywhere. So that's gonna prompt me to maybe ask some more questions, and maybe this is not even the picture I got with the application. So that's what would be helpful here. Here, maybe this is just, again, next to a church building, and they said it's a playground. You go out, this is what you see. Clearly this is a well-maintained piece of property. There's some basketball courts, a swing set. That's all I'd really be looking for here. And again, it's just confirming what's on the application or telling me, no, that's not what I see here. This is a real picture that Sabrina got with an application. This was I think a 20+ acre parcel of property, and I think it's owned by an educational institution. They said there were some educational activities, hiking, and different things going on. So all we get is this picture of the boy here looking studious with the weed in his mouth. So we need to know a little bit more than that. And yeah, it took us a minute to see it as well. There's he actually has a weed in his mouth. But so they say it's hiking trails. Well, do you see any trails? Is anything mowed out that you can see? Is there any signage, any markers? Do you drive by there randomly during the week? Are there kids out here? Is there really anything going on, or is this just like a staged photo opportunity here? There are definitely ways to ensure speedier processing of applications. And so a lot of times I think people come into the assessor's offices and they're looking for help, but also for attorneys in here who help taxpayers with this. This is what we would say. There's a list of required supporting documents on the application. Submit all of those when you file your application. If you get a letter from our office and we ask you for additional information, respond promptly. Make sure that we have the most recent contact information. Maybe the person that filed the application was the church treasurer. That person's no longer church treasurer, so that address we have is not correct anymore. Make sure that you update us and give us the correct information. You want people to update us or the county assessor of any changes that have occurred since they applied. Maybe they applied, they don't have a decision yet, something has changed, let us know that. Also, we would advise if they do come to your office for help with the application process, make sure, they may have more than one parcel that's not exempt, and they need to apply if they want to. Maybe they have a parcel they know doesn't qualify for exemption. They don't need to apply for exemption on that. But you may say, hey, what about this? You've got 2 parcels here, You guys are kind of the first line out there at the assessor's offices, so it's helpful to check to be sure that they are filing on all properties that might be eligible for exemption. I know a lot of times we have applications and then later on we've closed it, we've approved it, and later on church calls and says, what about this property? I meant to apply for exemption on this parcel too. And that's a little bit of a hassle. The only real assessor required duty is to retain copies of approved applications. Remember, this is going to include partials because there's a portion of the property being approved for exemption. The copies may be stored electronically. We've been getting a lot of questions lately about the appropriate method for storage of these documents, so we can't really provide an answer to that question, but I have put a cite to 10.7.121 up here, which applies to government records kept on computer or removable storage media. And we would refer you to the Office of General Counsel with any questions about interpretation. Also, keep in mind that both the applicant and the assessor have the right to appeal an initial determination. So if assessor gets a determination and does not agree with that determination, you have the right to appeal just like the applicant does. There's a few situations after we approve an exemption that may arise that could require action by either the assessor or the state board. You could have a change in use, you could get a new deed, may have a name change, may have an organizational or structural change, or you might have a new addition or a new building constructed on a parcel that's already been approved for exemption. So grounds for revocation are set forth in 67.5 to 12B5. We have fraud, misrepresentation or erroneous information, change in use, abandonment of property. I would say the most common ones we see are probably change in use and abandonment of property. Who can initiate the revocation process? We can initiate it, the assessor's office can initiate it, or any person with knowledge can initiate it. There is no formal process for requesting a review, so if you go out and you see, I think this is abandoned, I think that, they're not having church here anymore, you can write us a letter, send us an email, let us know. So what will happen once we get that concern or complaint, we will initiate a review, and we will actually attempt to contact the property owner to respond, because we want to give them the opportunity to respond to the complaint. We have an old AJ decision that I was looking at yesterday where he discussed the fact that exemptions, I know we've been talking about exemptions being like a bus ticket. He said exemptions are like licenses, and he compared it to licensing under the Uniform Administrative Procedures Act. And so there's a provision in that act that basically says if somebody's gonna lose their license, they have to be given the opportunity to demonstrate that they're in compliance. And his belief was that our revocation statute was drafted to basically simulate that provision in the Uniform Administrative Procedures Act. And so that's why we're going to contact the property owner and give them an opportunity to respond. Once we complete the review, we're going to notify all the relevant parties. So we're going to send out a letter, and we're either going to say, yeah, you know what, I've looked into this and I find that there's probable cause to revoke. If we do find probable cause to revoke, there will be a recommended date in that letter. So it's like an effective date for an approval. We're going to recommend an effective date for that revocation. That letter is going to go to the complainant, it's going to go to the property owner, it's going to go to the assessor and the trustee. Once I send out that letter, the file is going to be transferred down to the Administrative Procedures Division, and the letter is going to inform the property owner that they have 90 days to request a hearing before an administrative law judge. Also, that letter is now, this is kind of new to the process. Used to, we would just issue a revocation, assessors would put the property back on the tax roll, and then maybe the property owner would request a hearing and get a different decision from the administrative law judge. That was getting a little messy, so now we advise assessor does not put the property back on the tax roll until you get an order from an administrative law judge. So once the file goes down to APD, either a hearing will be requested or no hearing is requested. If there's no hearing requested, they're going to issue an order, and it's going to be an order of revocation, and it will have a date in there that revocation is effective. I would say typically in the effective date of revocation, I'm gonna say is typically the date we send out that letter. The only time we're gonna go back retroactive is if there's been fraud or misrepresentation. If there's a hearing requested, the taxpayer will have a hearing before an administrative law judge, and the judge will make a decision and issue an appropriate order in that case. So when can an assessor put property back on the roll without, I guess, going through, well, you can put it on when you get the order from the AJ, but you can also put it on if you get a change of ownership, because as we, I think, said earlier, exemptions are not transferable or assignable. So if you get a deed, and we're gonna talk about that in a minute, you get deeds and sometimes it's obvious that it's changed hands and sometimes it's not so obvious, but you can put it on the roll when there's a change of ownership. And we say here, when in doubt, contact the board. And this is because in the past, abandonment or obvious change in use, assessors really just, put it back on the roll. That was grounds for returning the property to the roll. And we do discourage this now. It's just a cleaner process to get in touch with us. Let us take a look at it, let us make that decision, and then you will have a piece of paper that tells you, an order saying, yes, this is not exempt anymore, put it back on the roll. This is kind of a new, I guess, internal process that we have come up with in our office, and this is what we would recommend to assessors when you do get a deed. Sometimes you're gonna get a deed and it's gonna be clear. The new owner name's nothing like the old owner name. This is not gonna be viewed as a revocation because in your eyes, it looks like the property's been transferred, there's a new owner. Example here is just a totally different name, Grace Baptist Church to New Light of the Holiness Church. Put it back on the roll. If the new owner name resembles the old owner name, and that's usually going to be like an incorporation or some kind of a name change that's obvious to you, then we say you can either contact the taxpayer, you can contact the taxpayer and advise the taxpayer to contact us, or you can contact us and let us know and we can look into it. So what happens when there is a name change or organizational or structural change? Our approval letter really puts the responsibility on the taxpayer to notify us of such a change, but assessors' offices can do that as well. So if you get a deed, like I just mentioned, and you think, oh, this looks like a name change, let us know. We will then initiate a review and we will request the documents that we need to determine the nature of the change. If the taxpayer contacts us directly, we'll do the same thing. We'll initiate that request for documents and we will copy the assessor's office on all of that correspondence. Documents that are required in the event of a name change only, and I think we had a memo in that packet, went out to assessor's offices last year. So we would like a written statement from the entity that what has happened is a name change only and there's no organizational structure change has occurred. We want a copy of the name change documents. So for example, with a church, a lot of times they're going to have minutes from a meeting. It might have been a meeting of the congregation. It might have been a meeting of the board of elders. Whatever it is, we would just request that they send that to us. And any other documents related to the name change. So if there is a deed, obviously we want to see that deed. Documents required in the event of an organizational structural change are kind of determined on a case-by-case basis because those can be different things. Incorporations are kind of just your standard run-of-the-mill, but we might have a merger or something else that happens, and so we really are going to see what they say. For example, I had a church contact me a couple of weeks. They told me they had merged, and so I asked the gentleman to send me the documents. When I got the documents, what had occurred was really one entity that was incorporated had dissolved and the property had been transferred to a brand new entity that had been formed and incorporated. So that's not really a merger and you're really looking at a different entity there. So in that case, taxpayer was advised like, hey, I think you need to reapply on this. So our review with name changes and organizational and structural changes is gonna result in one of two things. We're either gonna send a letter out to the taxpayer and the county officials saying, this looks like it's just a name change, or the organizational or structural change was not significant, and we're gonna say, hey, the property's still exempt. The second thing that could happen is we have reviewed everything, and just like the situation I just mentioned, said this is not a minor structural or organizational change. This is a completely different entity. And so in that case, the taxpayer was given a 30-day grace period to apply for exemption in that new church name with the new entity, and he actually came in and did that the other day. Had he not come in with that new application, I would have issued a finding of probable cause to revoke the exemption. So like we talked about before, I would send that letter out, file would go down to APD, and order of revocation would go out. And finally, this is a question we get quite a bit, new buildings or addition to buildings on property that's already exempt. Hate to keep using churches as the example, but really it happens most often with churches. So you get a fellowship hall that's built on a parcel that's already approved, or you get some extension of that property. So if it's a remodel or extension of a building that's already approved with no contemplated change of use in building, we don't require a new application. So if you know it's a fellowship hall, it's fine. We're not gonna require a new application on that. If a separate building is constructed and the land is part of a previously approved parcel, a new application is not required if use is consistent with that previously approved. So same thing, separate building, fellowship hall, no application required. But maybe you have a church building and now they've built a parsonage on that parcel. That's gonna require an application because that's not what we previously approved for exemption. That's a different use of the property. Then that's a situation we encounter quite a bit. And with that, I think that concludes my portion, but now we're gonna open it up for questions.
Should the UT football stadium be put back on the roll because it's not being used for football?
Yes, ma'am.
So you looked to the assessor's office to assist you
Yes,
in arriving at a decision regarding an application for exemption.
yes.
Once they are approved, where in the law, where it talks about the assessor's office should do a routine checkup to ensure that those approvals for use still exist?
So there's nothing in the law that I'm aware of that says that.
So do we rely on just willy-nilly?
Uh,
That someone tells us that
Yeah.
that charter school is no longer a charter school?
yeah, I mean, you can, if somebody contacts your office and says this property was approved for exemption and I don't think it's being used for that purpose anymore, let me know, and I'm gonna then look into it and
But do you
investigate.
not think it's important that we do that?
I
Because
think,
we
what I
have-
would say is I think a lot of assessors do it as part of their reappraisal process, that they'll take a look at some of these properties, because I think I'd get a lot of questions during reappraisal about, we've gone out and looked at these properties.
Yeah, I just wanted to add, like I think Emily was trying to say, there's no statutory requirement placed on the assessors of property, that they actually go out and follow up on these exempt properties and make sure that everyone is using it in the exact same way that they apply to. Of course, as this bus ticket analogy that we've kind of continued on in this whole process, is we want to make sure that those properties, do deserve to continue to be on exemption, but there's not a proactive requirement placed by the legislature on the assessment of a property to do that.
Well, would it not be the one that says we are required to identify, list, classify, appraise, blah, 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 blah? And if we're required to identify them, then it seems like we're required to maybe make sure that they're still exempt. Would it not fall into that arena, possibly? I mean, because once someone tells me that, hey, Vivian, your office is not picking this up, and they haven't been in school for a long time, they're not gonna look to you guys to go look it up.
Right, but it is like, and I didn't say this when I talked about revocations, but revocations can only be done by the State Board of Equalization. So there is no statutory requirement that you go out, and there's no statutory requirement that because we've had this discussion internally, should we make them report maybe once a year? So really, I think it's up to you, and like I said, I think a lot of people do it as part of their reappraisal process, but if somebody calls you and says that, I mean, that's why I'm saying complainant, anybody can, I guess, initiate what we call a probable cause review. So if somebody calls you and says that, we'll look into it and let us know.
Question back there?
We did a exemption back in our office, and we do not agree with it, and we contact the state board and explain our position, and the state board is looking into it. Time is running out on our appeal time.
So
Do I need to go on and appeal before the days run out?
generally,
We don't know.
when, I think we treat that as a request for reconsideration, and there's no formal process for doing that. So you have contacted me and said, hey, I don't think you knew about this, can you look at this? And so what I'm actually gonna do when I issue, I'm gonna look at what you have sent me, and then I'm actually gonna issue either an amended or corrected determination. It may not change the initial determination, but it'll have a 90-day appeal window.
Is the taxpayer notified that this is going on, or do they think when time runs out, it's over? Because that could throw them into a different situation. They think when the days for the appeal has run out, it's exempted, and then you come back and say, even though the days is out, it's not exempted.
So I think there's a couple of parts to your question. Is that, so first part is that yes, is that if you do contact us regarding additional information following initial determination has been issued, we can open up the file like Emily discussed for reconsideration. But for your appeal timeline, that initial determination, that appeal timeline does continue to run. If we do end up reopening the file for reconsideration or revocation proceeding, for instance, if you alert us after the fact and after the appeal window has expired, that that we were lied to, or there was a misrepresentation, or we didn't have all the facts, that would just be another revocation proceeding. For a reconsideration, if it's more of in that window of the taxpayer contacts us saying, hey, I think you got the date wrong or something, it's a correction that needs to be made. That's a little bit of a different process, but the appeal window will continue to run. So once that, we identify what that appeal window is and the initial determination.
But there is a new appeal window in the
And-
new determination.
Yes, but if there is a new determination that's subsequently issued, that appeal timeline presets. So essentially, every time you get that letter, it'll identify what that appeal window is, when that appeal window begins, and for when there is a reconsideration issued, the appeal timeline will be from the date of that letter.
Okay, back to my original question.
Taxpayer is not notified.
Okay,
So, well, it can work both ways though. Assessor can request a reconsideration, or taxpayer can request a reconsideration. So,
but because I notified y'all or talked to y'all and sent you more information.
right.
I don't have to file an appeal, is that correct?
I know the file that you're talking about, and there will be an amended determination, and it will have a 90-day appeal window that starts from the date that determination is issued.
Okay, thank you.
Any other questions?
Right here.
Oh, hey, John.
Discuss fee, how do you figure fee? If I've got 3 parcels contiguous, how we deal with fee?
That is changed.
So you should say that's changed.
So the fee structure as is part of the statute, part of 212, does discuss both the application. It says the application is a form prescribed by the board. So we do have a lot of leeway for A, our application, and then B, our fee. There is a maximum amount that we can charge for that fee, but it goes along with the application. So we do have a state board rule regarding fee and refunds of fees, but it's based, I think you have an attachment that's with you today, part of our packet that identifies kind of our fee structure as well. And so it will be based upon the total value of some of the property. But as we change our current application form, some of those fees, I will say, are subject to change. And so I think right now we charge a fee for the total value of the property. But as our application form sort of evolves, those fees are subject to change. And so I would like to make you aware of that, but more information about kind of what the specific fee structure and the maximum you might be able to pay, or might have to pay, is part of your materials today, but I think it goes up, so it's based upon the value of the property, and so it's the value of the total property you're applying on, if that makes sense.
I think we've gotten away from the contiguous, the contiguous parcel thing was not, I think, being consistently applied in our office, and so I think what we're trying to move towards is, correct me if I'm wrong, if it's 3 applications, the fee is going to be based on the total assessed value of all those, if they're filing them at the same time. So it's not going to be, we don't really care if they're contiguous. If they're filing 3 applications at one time, we're going to look at the total value to determine the fee.
Okay.
Now, can't speak to value because I don't, but exemptions, I
It's
know.
not a per parcel. It's not per parcel.
There's still the requirement that we receive an application per parcel, but I think the fee structure with the contiguous element was getting kind of convoluted and inconsistently applied. So now it's just the total value. It doesn't matter if the total value of the property encompasses 10 applications, you're paying your fee on the total value.
So the highest I'll ever pay is 120 at this level, at this point.
Yes,
Correct.
yes.
Okay, that's good information. I got 2 more questions. One is, I get a call from out of town. I'm thinking about building low-income housing. They just want information to be prudent with what they want to do. I'm not a lawyer. My answer to that is call the state board, and since you're my designee, I give Emily. And I don't know, and this is my question, who do I need to give them to? Because my thing is, she will not be able to tell you,
Yeah.
yes, I will exempt that over the phone.
Yeah.
But she will be able to tell you if something like that would be exemptable under these conditions.
Yeah.
Is that how you would answer that?
I think we're all willing to take calls like that, and I always give the disclaimer of like, I can't, you haven't applied, and so I can talk to people about what the law will allow, but I can't give you a determination based on a hypothetical fact set.
Yeah, we will always give out informational
Yeah.
materials about exemption law and exemption, what generally qualifies for exemption in Tennessee, and we can kind of help provide them more sort of any sort of administrative decisions or policy that's currently in place about regarding exemptions. But we won't make a sort of advisory opinion. We can't offer legal advice as if someone's property would or would not qualify for exemption. But we are all each more than glad to accept general questions about exemptions in Tennessee and exemptions and applying for exemptions with the state board and kind of what requirements they may or may not have to do in order to make those applications. And we have our general office number, which I think is 615-747-7883, which I don't expect you to remember that other guy, but they can, it's 401. But you can always call our general office number and you'll be directed to a specific designee. Or if you happen to know your specific designee, regional grand division person, you can obviously always contact myself or Sabrina or Emily.
You can give out my email address too, I don't care. Direct line, email, whatever.
Sabrina's phone number?
Well, the other day, we got a question, and it was just, whoever wants to take this particular call, because someone, I think he was in Texas, had a question about beekeeping, and wanted to know, Texas apparently has an exemption for beekeeping use, and he wanted to know if Tennessee has something similar. So I just said, I'll take the call. So I ended up talking to him. I've got to do some research Because apparently in Texas, it's similar to Greenbelt. They look at cattle, bees, and so it's all together, so it was just kind of interesting.
Real quick, one last,
Okay.
construction. Construction, when do you recommend us, if I get a call and say I'm about to start construction on a church building, and I send them an application, when do you want me to tell them to turn it into you? What's the time frame? Because I've maybe wrongly, I've said, when you're about to be finished, maybe like a use and occupancy, and then you all can address everything then, but what I hear you saying today is from the start, from the get-go.
That's pretty subjective. I think we all deal with it in our, personally, I would say the moment they start or they're about to start the construction, go ahead and send the application in. By the time I get to the application, the construction will probably be underway. It's still going to depend on the date that construction started anyway. As far as waiting until construction has been completed, we can put something in there that says, during the period of construction, the property was deemed exempt, blah, 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 blah. But if they go ahead and apply, and like Robin said earlier, we keep it for about a year anyway. So if they want to send it in when the construction starts, that's fine.
Yeah, I would just say that generally follows the same kind of effective date rules of a completed building. And so, I generally would look to see if, when they apply, or if construction has begun, they can have that sort of 30-day sort of, protective period as well. But the effective date of that construction will always begin, when construction begins. And so I would, preface that people most likely want to apply as close to that date. But they don't need to. Again, some of the property tax sort of arrangements are always a little bit complicated about who's going to pay it. There's a lot of contractual ways people contract around it. And so it really is going to be for when their tax bill, like what is their tax burden, and when does their tax burden begin, and all that sort of other complicated issues. And so sometimes it's harder to say if they should apply once it's completed, or they should apply once construction begins, because without us knowing what their specific tax burden or what they've contracted around is, it's hard to specifically advise, and we can't always do that unless we see their application.
Any other questions?
I have a college campus coming to our county, and it is going to be, it's starting out 2 buildings, then 4, then 6, because they're going to start with technical, then they're going to move our community college there, and then Tennessee Tech is going to have it. So we'll actually have a 4-year college. It's about a 50-acre tract. Right now, it is going into like a Lawrence County Educational Committee, some type of committee, because this committee's been working on this for 3 years. The county's going to eventually own it. We've got, I think, $4.6 million of state grants. We've got county money, a couple million's already went in, or $1.5 million, and then some private money. I'm not sure with all the paperwork that is entailed exactly when it's going to go into the county. They've already bought it, breaking ground probably as we speak, probably. How do I handle that? I mean, do they need to go ahead and apply? Because I've talked to the county and they tell me it is going in there, but I don't know when, and is there even a reason to until there's a building there, or how do I need to handle that?
Could you repeat that, what she's saying?
She's saying that there's a college, let me know from, there's a college coming into her county, and they haven't started construction yet. It's going to ultimately be multiple buildings, and apparently ultimately the property will be owned by the county. And she wants to know at this point, how does she need to handle it? Does the applicant need to go ahead and apply for exemption, or since she's not sure when it's going to be owned by the county, should that just wait? Again, construction is very interesting. I'll give my answer. I would suggest they go ahead and apply in their own name. They own it. Is it a college? You said it was a college?
Is it
Is it a nonprofit?
Yeah, I mean, it's going to be, it's West Tennessee Tech.
The one, but whoever owns it right now.
Yes, it's a group, it's a committee that Lawrence County has put together,
Mhm.
commissioners and business owners, attorneys, that it's just in that committee name, which I think they have all the documents for that, putting them that committee just for this college. So it's actually, the needs already coming through, it's going into that name now. And I went to the county executive and I said, at what point is this gonna go into Lawrence County, because I can't exempt this, and he said, I'm not sure about that. I mean, it's going, but it has to be a process.
So is the current owner like a nonprofit?
Yes.
Yeah.
I mean, it's just a group of commissioners, and like I say, they're just, it's just that Education Foundation, or I don't know exact wording, is the name it's going into, which yes, it is gonna be a nonprofit, and then they will convey it to the county at some point. But I'm gonna have to have it on the roll now, and the ground is breaking probably as we speak. And the first 2 buildings are gonna go up, and then in a year, the second 2 buildings, and in a year, that's what I've been told. So, I mean, to get a college like that, a 4-year college in your county, you're not gonna be able to pay taxes. There's not, on buildings of that caliber. So I'm just trying, I want them to be exempt, so, of course, because I think it's a great thing for our county, but I just didn't know how to handle that.
Well, I'll give my suggestion. I would still suggest that they apply. That way, they're covered, protected in case they are exempt. Secondly, it gives us an opportunity to look at the documents, and then we can determine if it's an eligible entity. So I would suggest doing that, and at the point it becomes county-owned, then 67-5-203 would kick in, the governmental entity.
Okay, so, but can they get exempt until the building's up, the first building's up?
The land would not
The
be
land
eligible
tax.
for exemption.
Yeah.
Until that first.
That's the thing about the construction statute, it's exempt to the extent of the value of the construction improvement, but the land is taxable during the period of construction.
Okay, so they're gonna have to, they need to get it in the county as soon as possible, because that land's never gonna be exempt until it goes in the county or a building is there, is what you're saying.
John?
I asked you at break, and Betsy, this may be a question for you. When you
Oh, yeah.
when you put this up on the website, will there be any notification going out to the assessors or such, or you just gonna put it out?
Certainly, we can do that.
I mean,
We'll just send a link to the assessors.
that'd be great, because I mean, if you're not, I visit the assessors, and I'll be glad to make sure that the ones that aren't here, we've got a lot.
Sure, yeah,
But I'd like for them all to be able to see it.
absolutely.
Okay, thank you.
Any other questions?
Vivian, did you have a question?
No, not at all. My colleague from Lawrence County, from what you just presented to us, or they can lease out to a youth group and let them practice football. That's what I picked up from the presentation. Anyway,
If there are no other questions at the moment, I just wanted to say that during the break, there were some really good questions asked. One question had to do with the YMCA. When I was talking about the YMCA, and I was saying that there's a statute specifically that addresses that, I didn't mention that if there's a smoothie king or some kind of revenue producing entity in that Y, that would not be exempt. So just like the VFW post and just like the labor unions, if there's a revenue producing component to it, that would not be exempt. The other thing is that, oh, Emily, there was a question about the website for medically underserved areas. Do you remember that?
Who wants to know that? I can email it to you. I'll email it to you. I can email it to you guys, the link.
Wanted to re-emphasize that the nonprofits can make a profit. So that was a question that came up during the break. The collection process should stop while a case is actually pending before the board. So if you have an exemption application, it's treated the same way as a pending appeal. And with appeals, they have to pay the undisputed portion. But in the case of an exemption, there's generally no undisputed portion because they're claiming that all of it is exempt. So during that period when they have something actively pending before the board, the collection process should stop in terms of delinquent interest and penalties.
Yeah, I think I was just going to add, so one more comment. And again, so all these initial determinations, whether you're approved or denied, or it's a partial approval, are appealable. And so both the applicant can appeal as well as the county assessor, which is Emily has touched on. For putting it in frame of kind of the example we did today, in the real life example, the church ended up appealing, but not based upon the lack of acreage, but upon their effective date. So oftentimes you'll find people who actually get approved for exemptions still appeal because they need to go back further because their budget doesn't allow for previous tax years that they, were unfortunately didn't apply early enough. And so they can both appeal, and that does happen fairly often. So it's important that, people are involved in that process and both parties can appeal. And when they appeal, they both go, it's very similar to value appeals. So they'll go to an ALJ, and the ALJ will kind of hear that issue as well. And then they can also appeal to the Assessment Appeals Commission regarding their exemption. That's the last administrative step before they go to Chancery. Any question?
Taxpayer appeals, does the taxpayer appear before the ALJ and the representative from Board of Equalization appear?
So the administrative law judges can request our presence there. They can request that, or they request that we answer questions as part of that hearing. I think Emily has done this more than, again, I've not yet had that equation, but I think Emily has a better response.
There's a state board rule, and I don't know it off the top of my head, but the county assessor can request the designee's presence at a hearing, and we do have the right to participate telephonically.
And you don't need to subpoena them. Just FYI.
What about if the
You just ask
assessor appeals?
them.
Either, the assessor could still request. I would only really, if the designee does participate, which I have done a few times, usually I end up just sitting on the phone not saying anything, but we would really only testify, I guess, about what kind of went into our decision, how we reached our decision. We can't, I guess the point is, we can't be an advocate for the county. We're not a party to the appeal, so we can really only testify as to how we reached our decision.
Well, I guess that's what brought my question, that the county doesn't need to be defending what y'all do. Y'all
But-
made a decision.
I understand it is strange, but that's how it works. We are not a party to the appeal, so unfortunately, taxpayer appeals, then county is the other party and not the state board.
It's strange.
It is strange, we know
If I
that.
get an appeal, you'll be called. Be ready.
Okay, so the assessor be the person that wants to revoke the exemption. Do you have some type of letter? My office may have one, so, I have a great staff, but one thing I noticed is that it is stated that they must request a hearing before the ALJ in 90 days. If they don't, the ALJ issues an order. So the assessor wants to revoke an exemption. We got something like that about to happen or could happen. Do we need to put it in our letter that we send to the property owner? That, in fact, they have to request a hearing, and we're giving the evidence of why we're asking to have that exemption revoked? How does that work?
Really, you just need to, your office needs to notify me.
Okay.
And I do all that. I'm the bad guy, so I do all the investigating and
Would that be the
review.
same for Greenbelt rollback?
No, we don't do green belt rollback.
Call Dawn.
When we were going to have this seminar in June, we asked for some questions that you had, or some frequently asked questions. And at that time, some were submitted. One question was, who can live in a parsonage and it remain exempt? When I was doing my portion, I was saying that the law allows one parsonage per church. But if the main pastor owns his own home, then it's possible that a youth pastor, and we've even had, because of the significance of the ministry, a choir, ministry of music, actually living in a home and it being approved. So, so that's the answer to that question. Is there a limit on the number of rooms that a parsonage can have? As I showed in the Kardashian picture, no, there's not a limit on that at all. Is it okay to consolidate an exempt parcel and a non-exempt parcel? Please don't. It's just really not, it is messy, it causes a lot of issues, and there are entities that have almost lost their properties because of that. What if the taxpayer is not happy with our initial decision, and Robin just mentioned the levels, if they're not happy, you know, they go to the AJ and then the commission. That's the last question that was submitted. So do you have any additional questions? Oh, right here, sir.
One thing you just said,
Okay.
a church has their church building and a spot of land. They buy an acre of land from the neighbor, and they come in and they say, I want this joined with the church land. Don't join it together.
What we recommend is that you tell them to apply for the exemption for the 1 acre
For that acre.
and see if that gets exempt. Once it's exempt, then consolidate. It just makes it a lot cleaner. So.
I think, because, so part of the example of what can happen is that if a church buys the neighboring parcel and combines that parcel into one parcel ID, it tracks very weird because their bus ticket will say their original parcel number. So if they keep it, you know, it looks like they're exempt, but they're not. And so often what happens is that for their property assessment, they'll have a subsequent like property card that'll identify that they are still taxed on a portion of that land. But the applicant looks at their bus ticket and says, no, I'm not. It says right here, it says I'm exempt. And so it can just lead to a lot of confusion. And again, because the three worst organizations, churches, schools, and law firms, it can be very hard on some of these smaller churches to sometimes identify what their property tax burden is or is not. Although, you know, it is their choice usually if they want to apply to combine that parcel, but it can cause a lot of complications. And so what can happen is that a church can get an exemption combined with the parcel next door, but still get a tax bill. And if they continue to not pay that tax bill 1 year after another, their entire parcel, their church that was previously exempt, because it's now been conjoined, it might go up for auction. You know, they could run into a lot of legal issues with losing ownership of their church. And so, you know, we just generally recommend that churches, because they don't need to combine their parcels, again, because if they're exempt, even if they, you know, are different parcels, they still have no tax burden if they're all exempt. And so they can combine them, but it's not best practices.
The last question that was asked during the break had to do with chambers of commerce. And when I was talking about the different statutes, the branches, I mentioned 67-5-210, which was that economic development statute. And so I had a call from a lawyer in Memphis, and the question was, can chambers of commerce come under 210? And the answer is no, because 210 specifically says a 501c3 organization, and a chamber of commerce is a 501c6. So the answer was no. Any other questions? Vivian?
Okay, Community Review Assessment. There was a piece of legislation that affected primarily Vanderbilt, that gave them some, you know, to go back a couple of years. I think there was also another one from Harry. You mentioned that there was another. Could you talk to us a little bit about that legislation?
Which one, Meharry or Vanderbilt?
Go with Vanderbilt.
Vanderbilt, Sabrina has the statute book, I think, but basically what happened with Vanderbilt is that the university and the medical center separated, and so the medical center became an entity that was separate, and so some of the properties that were owned by the university then turned around and leased to the medical center, and under 212, those with, 212 as it was at the time of this transaction, those properties did not qualify for exemption. I think the way it worked, the buildings actually were owned by the medical center, but the underlying land was not. And so Vanderbilt had a piece of legislation pushed through last year that basically said if you have two entities that sort of form out of one entity and the property was exempt before that happened, that basically it would, and even if there's a lease agreement, that it would still be exempt.
And they were paid, their rent was a lot higher.
Their
than
rent,
the cost.
yeah, it did not qualify under 212 as it was because the rent exceeded a reasonably allocated share of cost of use. So we had concerns about that legislation because we had concerns that that opened the door for some other entities, and I do believe we have actually seen that come into play in a couple of other situations. Matt, did you want me to talk about Meharry? Meharry, I think Meharry basically was an effective date issue, and so it is a very, very specific piece of legislation that applies to a medical college, and it essentially allowed me to apply a 3-year go back.
Was it medical college, educational?
I believe it specifically says a medical college because we had some concerns about that. There's not a definition for what a medical college is, so I don't know, in the future what that may apply to. But right now, the only thing I know of that it applies to is Meharry, and at the time, we had an appeal pending on that.
Certain educational institutions, and it mentioned the residents and the faculty or staff of university. So is that property that's owned by the university but just occupied by their faculty? Right. Okay.
By staff.
And there's quite a list of requirements there that we have to look at.
675213,
Okay.
a list of, can't own it after they cease employment, that type of thing.
Okay, so basically the faculty member cannot buy the property from the university.
If they do, it's no longer exempt.
Okay.
Yeah. Okay.
All right.
Thank you.
Thank y'all.